Hi, this is Gauri Molekhi from People for Animals. Welcome back to Ahimsa Matters. We tend to use the terms confiscate and surrender very loosely, probably in the same vein as we have heard our teachers use when we were in school. But in the legal parlance, their meaning is very different. Today we're going to understand what are the laws and provisions regarding taking an animal away from a cruelty situation. So in the previous video, we've already seen that section 32 and 34 of the Prevention of Cruelty to Animals Act empower the police, the jurisdictional police, to enter and search a place where cruelty is reported. Thereupon, they can seize any animal that they find is being treated cruelly. Any other authorized person or any other person specifically authorized for search and seizure can also seize an animal and produce it again before the jurisdictional police. The first step after seizure is very important. It's about making a seizure memo or a fard, as we can call in Hindi. The provision for these are under section 100 and 103 CRPC. The seizure memo is made by the police with the description of the animal that is seized, and a copy of it is given to the owner of the animal from whom the seizure has been made. A seizure memo will not only record the species of the animal or the number of animals or the color of the animal, etc., that is being seized, but also any other evidence that may have been collected by the police from the scene of crime. It could be a weapon, could be a cage, could be any other thing that is pertinent to show to the magistrate later on that cruelty has occurred. The second step is to make a general diary entry or the daily diary entry, as the police are required to make under the State Police Act, based on the written complaint given by the complainant. So the complainant can describe whatever has happened and what his information is, and that information is recorded in the daily diary entry or the general diary entry of the police station. If the SPCA has seized the animal, the SPCA is authorized in certain cases, specifically authorized to seize animals. They also need to produce it before the jurisdictional police station so that the formality of the seizure memo and the DD entry can be completed even in such cases. In the third step, the police has to make a request to the Animal Husbandry Department. This is done by writing a short letter called a VLC or Vetero-legal letter to the Jurisdictional Veterinary Officer, asking him to conduct the health examination or post-mortem, in case the animal is dead, of the animal in question, and submit a report with the investigation officer. In case the post of the veterinary officer is vacant in that jurisdiction, the letter can be directed to the chief veterinary officer or the district animal husbandry officer of the district, and that officer will depute one of the other animal husbandry officers to conduct the health inspection of the animals in question. The report needs to be submitted to the investigation officer and not to the complainant. That is the process. So the health inspection report or the post-mortem report are basically evidence which must go from the animal husbandry officer to the investigation officer and then before the magistrate. This is the chain of custody which must not break. Hence, if the complainant requires a copy, can definitely obtain it by applying for a certified copy in court. But aside from that, it's not customary to provide a copy to the complainant. It goes without saying that if the seized animal is injured, necessary first aid and treatment must be provided by the jurisdictional veterinary officer. Now we come to step 4, which is very important. As per Rule 3A of the Care and Maintenance of Caged Property Animals Rules 2017, the jurisdictional veterinary officer must identify all the animals and conduct a thorough health examination. In order to identify each animal, if it's a large animal, he would provide a Permaflex tag to put on their ears. It's a tag which is made available by the Government of India to all districts in this country. Each of these tags has a barcode and a 12-digit unique identification number which is not repeated anywhere in the country. Alternatively, for smaller animals or for animals for which Permaflex tags are not reasonable, a radio chip can be inserted behind their ear under the skin. These tags are also available for 100 rupees in the market, the cost of which has to be paid by the accused. We'll come to that later. That is your step 4. In step 5, the jurisdictional vet needs to provide first aid or treatment to the animals as necessary and create a Panchnama in accordance with the provisions of the CRPC. Your sixth and final point is for the police to review the facts and circumstances of the case and see which sections of which acts have been charged, and thereafter either write a first information report in an FIR diary, which then needs to be produced before the magistrate within 24 hours. If no cognizable section is made out, the police will write the complaint in an NCR diary, which is produced before the magistrate from time to time. So now you understand the process of getting to an FIR. Just going to the police station and orally insisting on an FIR will not get you there. There's a lot of paperwork that is required to be done, processes to be followed. So it's very important for the complainant to carry a detailed written complaint with him and cooperate with the police with every step of the procedure, because this procedure is set in stone, it's laid down in law. You can assist the law enforcement agencies and help animals better rather than questioning them without knowing the law. So all power to you for helping animals, and do watch this space, follow this channel. Bye-bye for now.